when I filled out the form at the AEC office, I struck out the word citizen and put subject. Okay, and as far as I understand, and I went through that form in detail, that's the only unconstitutional words that are in that document. Okay, so I can't see any challenge being put.
Subject, not sovereign person.
That's right. Oh no, you're a sovereign subject of the rule of law. You're not a citizen.
No.
That's right.
Fidel Castro doesn't rule me.
That's right. You rule you, and you're obliged to the rule of law.
Joe, what does that mean for people who become citizens of Australia? When they
Well,
get the Naturalisation Act?
they are under duress.
My son-in-law's just done.
Yeah, I know. I'm dealing with someone who's they're trying to force into becoming an Australian citizen, and they cannot do this. But this is a corporate government doing this, not a constitutional government that's doing this.
What should be the right wording for that?
Well, you're what with respect to the election?
You take away the Australian citizen.
Yeah.
And then what do you put in there for the...
A subject as defined under the Constitution of the Commonwealth.
Oh.
Yeah.
You better get back on the courts.
Back onto the courts.
What you do, otherwise we're never going to get
Back onto the courts. Okay. Okay, what do you do when you are confronted with a demand first? It'd be an infringement notice, usually. We usually reply to that infringement notice, and in that reply we would first ask them, why are you referring to me in the capitis diminutio? Why in the capital letters? Why? Okay.
Their names seem to be verse. Yes, surname, Christian names are going to send out.
Yeah, it's still all capital.
That's not to go, it's an assumed name.
Yeah, it's an assumed name. Yeah. So you establish with them first and foremost that there is two entities defined in the Black's Law Dictionary, and I'm not taking any responsibility for the Roman entity or the one referred to under capitis diminutio. Okay?
Says they won't reply to that.
They won't. No, what they do then is they usually put a form to you named a revocation form. Okay, and usually on about the second or third page it will say why you are revoking their claim. Okay, and then you repeat what you've put in the first letter, because otherwise they have nowhere to file this stuff. Okay, that's what it comes down to. I've had them tell me this. We've got nowhere to file these notices and the like of demand. So they have to file it under revocation, and when we attach it to their paperwork, they usually put it to a review panel. Right, now, who these people are, I do not know. But it comes under what's called, here in Victoria, the Infringements Act 2006. And that act did not follow the proper due process to make a law. Okay, so we point all of these things out. We point out our obligations under the Constitution, and that any inconsistencies under Section 109 have to be treated as void. Right? So then, let's say they take us into court, or they demand that we go into court. It will be, you'll be served with a summons, and that summons will have it down as a summary offence. Okay? And
State regulations too.
yeah, it'll cite the Road Safety Act 1986 or whatever. Okay. And then I would go into that, I would then type out the inconsistency that they're relying upon with respect to the Constitution, and how the Road Safety Act or the Local Government Act or whatever state law they're relying upon is inconsistent through that due process.
Section 92.
Now, with respect to the Road Safety Act, this law was not assented to properly under the Queen's name. Right? There is an inconsistency with respect to laws drafted prior 1986 and after. And you just go to page 1. And page 1 will say the Parliament enacts as follows. Prior 1986, it was the Queen's Most Excellent Majesty on and for and on behalf of the Legislative Council, the upper and lower house. So it's showing you the proper structure, the separation of powers in that opening statement. Now, with respect to Section 4 of the Road Safety Act, it will say that this Act is drafted for and on behalf of the Crown in all its capacities. Okay, the Crown in all its capacities for the state of Victoria. Right, now that statement, that section is void because the Crown is indivisible and has been established in High Court case after High Court case. The Crown is indivisible. You cannot have the Crown in the right of a particular state. The Crown is here as the Crown, with the representative of the monarch being the Queen, and that is for the Commonwealth, not for Victoria exclusively. This is where the Australia Act has separated and divided the Crown up. Cannot do that. Okay? So we break down the inconsistencies as we've been shown here, as you've learned, as you'll see on our websites, those inconsistencies. And we prepare those documents and we have them ready to hand up to the prosecutor, preferably prior the court case. Okay? Before we get into court, we let them know where we're standing and that we are subjects of the Australian Constitution, and that we demand that any court they put us into is a court that is defined under Chapter 3 of the Australian Constitution.
When you present the laws that you're citing, do they have to be from the government printer, or can you just download it from the internet?
No, the internet is only there as a guide, and you'll read on Austlii, it is not to be used in court. So we urge you to go down to Information Victoria and grab a copy of whatever law they're grabbing you under. Okay, read it for yourself. You'll also note, as I've said earlier, look for the inconsistent clause. It's there, gentlemen.
Wouldn't the magistrate say, what are you coming about? I don't know.
The magistrate will first ask you in the plea hearing, or the mention, it will be to find out what you are pleading. A, he'll find out whether you're represented. Okay. B, he will find out what you're pleading. You'll get 3 choices. You'll get a guilty, a not guilty, or a no plea. Okay. How can you be guilty of something that isn't law? If you're there to challenge the legislation, then you cannot, in my opinion, apply a guilty or a not guilty. The only zone you really can stand in is no plea. Then we challenge the jurisdiction of the court. Okay? We're here to ask the court if this court is in federal jurisdiction. Section 71 of our Constitution